It is indeed a great personal privilege and pleasure to be able to introduce our conference keynote luncheon speaker for today. Erwin Chemerinsky is the founding dean and distinguished professor of law and the Raymond Pryke Professor of First Amendment Law at the University of California, Irvine School of Law, and of course he holds a joint appointment in political science. You have his biographical sketch in your program, so I'm not going to repeat that. But I would tell you that his CV is 59 pages long. And it's very difficult for me to get and convey to you the measure of the man in the brief time allotted to me. First and foremost, though, Erwin is regarded as one of the country's leading constitutional scholars. He's widely published, and some of his recognized texts sit on bookshelves all over. The Constitutional Law Principles and Practice Treatise and his Constitutional Law Casebook are used in law schools and by law firms. And of course, his newest book, The Case Against the Supreme Court, I think, as Charlie mentioned, Erwin will be signing copies of that book after this. He first entered the academic community back in 1980, where he taught for almost 4 years at DePauw University College of Law in Chicago before joining the law faculty at the University of Southern California. Now, he stayed at USC for 21 years. I think he loved it there until he was finally lured here to Duke on the East Coast in 2004 to join our faculty. To my regret, he stayed here only 4 years before he went back to the West Coast to be the founding dean and create a new law school at UC Irvine. Although Erwin continued to come to Duke every year after he left our faculty to participate with Chris Schrader and several other of us who put on a program for federal judges each year. Judge Whitney is participating in that program. Erwin would take a red eye in from California, arrive, speak eloquently for about an hour and a half, and then fly back to California. And the federal judges attending those programs every year would say, you know, you've got to stay. Now, something you might know about Erwin is that he grew up on Chicago's South Side, and his father, who, correct me if I'm wrong, Erwin, he was an auto mechanic who later managed a home improvement store, made sure that Erwin was able to attend the prestigious University of Chicago Laboratory High School. Erwin once described that experience as life-changing and a wonderful intellectual experience. Now, another thing you may not know about Erwin is that he thrives on very little sleep. I would get emails from him at 2 o'clock in the morning and then also at 5 in the morning. Perhaps, I guess, he gets no more than 4 hours of sleep a night. One of his friends at USC once commented that Erwin sleeps on leap years. Finally, a part of Erwin really never left Chicago. He's a diehard Cubs fan. One of his colleagues at USC once said that Erwin's dream, his fond dream, was to be able to argue before the Supreme Court in Wrigley Field, the Cubs Stadium. Now, that may be apocryphal, but I doubt it. Like many of his friends here at Duke Law and elsewhere, although we may disagree with Dean Chemerinsky on issues of law or policy, we hold him in the highest esteem. Scott Altman, who taught it with Erwin at USC, said that the most important thing about Erwin is that he is a ceaselessly decent and kind person. And Erwin and I couldn't agree more. That phrase, a gentleman and a scholar, fits you like no one else. I was once told that no introductory comments could be all bad if they were short enough. So I'm going to leave it there. Please join me in welcoming back to Duke Law School Dean Erwin Chemerinsky.
Thank you so much for the incredibly kind introduction. I wish my mother could hear that introduction. It means so much coming from Scott. I had the chance to read Judge Silliman's opinion in Hicks versus United States, and I felt so honored and proud to be able to say that Scott's my friend. It is wonderful for me to be back at Duke Law School, As I was flying across country yesterday, I was very nostalgic and thinking about how much I miss Duke and all my friends here. Then I stepped out of the airport terminal, and then living in Southern California doesn't seem so bad. I also want to thank those responsible for the conference for putting out a table to sell my books. I had nothing to do with this. I'm a bit embarrassed by it, but I'm really grateful. Throughout American history, whenever there's been a crisis, especially a foreign-based crisis, the response has been repression and the loss of civil rights. Unfortunately, in each of these instances, the Supreme Court has failed to enforce the Constitution and protect civil rights. That's part of the focus of my book, The Case Against the Supreme Court. In hindsight, in all of these instances, we realize we weren't made any safer as a nation by the loss of rights. Think about this history just for a moment. In 1798, while the survival of the Republic was still in doubt, Congress passed the Alien and Sedition Act that made it a federal crime to falsely criticize the government or government officials. Individuals went to prison for speech tamer than what Jon Stewart says on a nightly basis. Thomas Jefferson ran for president in 1800 in part on a platform of pardoning those convicted under the Alien Sedition Act and having the law repealed. That's exactly what occurred. Many years later, in New York Times versus Sullivan, the Supreme Court said that the Alien Sedition Act was declared unconstitutional in the court of history. It's a wonderful metaphor, but it can't obscure the loss of rights and the people who went to prison for their speech. As we all know, during the Civil War, Abraham Lincoln suspended the writ of habeas corpus, even though the president clearly has no authority to do that under the Constitution. What we tend to forget is that hundreds, maybe thousands of individuals were imprisoned without habeas corpus just for their speech, just for criticizing the way the North was fighting the Civil War. During World War I, Congress passed two laws, one in 1917 and one in 1918, that among other things made it a crime to criticize the draft or the war effort. One of the first major Supreme Court cases about free speech, Schenck versus United States, involved a person who was convicted under the statute for circulating a leaflet that argued that the military draft was involuntary servitude in violation of the 13th Amendment. There wasn't the slightest evidence that Schenck's leaflet had the slightest adverse effect on military recruitment or the war effort. Nonetheless, the Supreme Court affirmed his conviction and his sentence of 10 years in prison. During World War II, 110,000 Japanese Americans, aliens and citizens, and 70,000 were United States citizens, were uprooted from their lifelong home and placed in what President Franklin Roosevelt referred to as concentration camps. Not one Japanese American was ever indicted or convicted of espionage or crime against national security. Race alone was used to determine who would be free and who would be incarcerated behind barbed wire, often housed in horse stalls. One more example, we can think of the McCarthy Era, the age of suspicion, a time when merely being suspected of being a communist was enough for a person to lose a job or maybe even liberty. Here, the leading Supreme Court case, Dennis versus United States, involved individuals who were convicted just for organizing to teach the works of Marx and Lenin, Engels. Their crime was conspiracy to advocate the overthrow of the United States government. There was no proof introduced that their speech would have the slightest adverse effect, and yet the Supreme Court, in an opinion by Chief Justice Fred Vinson, said, when the evil is as grave as the overthrow of the United States government, there doesn't have to be any proof that the speech increases the likelihood of that happening. In light of this history, it was predictable that the offense of September 11th would lead to repression and the loss of civil liberties. But in all of the instances that I just related, The loss of liberties ended when the conflict ceased. In fact, long before September 11th, it caused me to wonder if we don't have a deck chair theory with regard to our civil liberties. We put our civil liberties out like deck chairs during the good times, but then in the bad weather, we bring them in. We no longer have them and no longer follow them. And this is certainly something to be criticized, but always in the past, one thing that could be said, it was temporary. But what if the bad weather doesn't end? What if it's likely to get worse? My guess is that everyone in this room believes that there will be other terrorist acts, maybe even worse than the ones of 9/11, that it's a question not of whether, but of when. What then of our civil liberties and civil rights? What I want to talk about this afternoon in discussing civil liberties in a time of forever war is what's the legacy of what's occurred since September 11th with regard to our civil liberties and our civil rights. As I talk about this, I also want to keep in mind some words of Justice Robert Jackson in his eloquent dissent in Korematsu versus the United States. He said that what the court had done is set a principle that lies like a loaded gun to be used by those in positions of authority when there's a plausible claim of an urgent need. To what extent will the loss of civil liberties and civil rights that we've seen since September 11th be like that loaded gun to take away even more rights in the future? In addressing this question, I want to focus on 4 examples, and then I want to try to put them together and look overall at what they tell us. The first example I want to talk about is the loss of freedom of speech since September 11th. I'm surprised that this has not received more attention. The key here is the federal statute, 18 United States Code 2339B, that makes it a federal crime to materially assist foreign terrorist organizations. Individuals have been convicted and imprisoned under this law just for their speech. Individuals have been convicted and imprisoned under this law without any showing that their speech was likely to cause harm. There's one Supreme Court case about freedom of speech in the war on terror since September 11th. It involved the reach of the statute. I'm sure it's familiar to all of you. It was Humanitarian Law Project versus Holder in 2010. It involved 2 groups of Americans who wanted to give peaceful assistance through speech to groups in foreign countries. One group of Americans wanted to advise a Kurdish group that wanted to form a separate country on how to use the United Nations to peacefully resolve their disputes. The other group of Americans wanted to help some individuals in Sri Lanka so as to apply for humanitarian assistance. At no point in any of the protracted litigation was there a claim that the Americans were assisting with regarded as terrorist activity. At no point in the protracted litigation was there any allegation that this was anything other than the speech that I described. But the Supreme Court ruled 6-3 that these groups could be found to violate 2339B to be materially assisting a foreign terrorist organization. Chief Justice Roberts wrote the opinion for the court. He noted that both the Kurdish and the Sri Lankan group have been designated by the government as foreign terrorist organizations. The court stressed the need for the government to protect national security. And the court said, even when the material assistance is speech, it constitutionally can be punished under this statute. There's no First Amendment right, the court said, to speak in a way that assists foreign terrorist organizations. Justice Breyer pointed out in his dissent, as I already have observed, there was no evidence offered, none proffered, that this speech would have the slightest likelihood of increasing terrorist activity. One of the important advances in First Amendment law occurred in Brandenburg versus Ohio in 1969, where the court said that advocacy could be punished only if it was directed at causing imminent illegal activity, and only if there was a likelihood of imminent illegal activity. And yet, nowhere does Chief Justice Roberts' opinion mention the Brandenburg test. Nowhere does the court say that speech can be punished only if it's directed at causing imminent illegal activity, and only if there is a substantial likelihood of imminent illegal activity. There have been many lower court cases where individuals have been convicted and sentenced, including for long periods of time, just for their speech. I would mention as one example here a Second Circuit case, United States versus Farhan. This involves a doctor. He took an oath to support al-Qaeda. He said he would provide medical assistance to terrorists who were injured, including in terrorist activity. He circulated his phone number within those who might need that type of assistance. This is all he did. It was speech. At no point was he accused of providing medical assistance to a terrorist. At no point was he accused of providing any other kind of assistance to a terrorist. It was his speech, his oath to support al-Qaeda, his pledge to provide medical assistance. For just this and no more, he was convicted of violating 18 United States Code 2339B and sentenced to 300 months in prison. Where was the proof that his speech was directed at causing imminent illegal activity? Where was the proof that his speech had any likelihood of increasing the chances of imminent illegal activity? Or to pick just one more example, I can pick High versus Department of State. There, the United States Court of Appeals for the District of Columbia Circuit said that a website itself could be designated as a foreign terrorist organization. This was a website linked to an extremist group in Israel. It's not that the government was saying that the speech on the website raised a risk. The court said that the website itself was a foreign terrorist organization. I could go through many other examples of this, though as I said, the interesting question for thinking about is, why hasn't there been more attention to the loss of free speech as a result of the war on terror? Why hasn't there been more attention to those who've been convicted and sentenced for nothing other than their speech? The answer for me is disturbing. It's because the people whose speech is being punished, the people who are going to prison for their expression, don't look like most of us in this room. And it's not our children or our college students out on the streets. It's those who are others. So it becomes much more acceptable to tolerate their loss of free speech. Let me choose a second example to talk about with regard to the loss of civil liberties as part of the forever war. And that's the loss of privacy, and especially the loss of the ability to challenge the diminishing of our privacy. There's no doubt that September 11th changed the function of law enforcement in this country. Traditionally, we turned to law enforcement at all levels to solve crimes, to gather evidence that would be used in prosecutions. But after September 11th, we want law enforcement to prevent crimes, to prevent terrorist activities. Gathering information becomes crucial then for law enforcement to achieve its goal. Whenever the government is gathering information about individuals, inherently there are concerns with regard to privacy. It's not surprising that the Patriot Act, the first major statute adopted after 9/11, was largely about increasing the tools for the government for gathering information. Things like roving wiretaps, sneak and peek warrants. Section 215 of the Patriot Act expands the ability of the government to gather information just by request. And when the information is turned over, those who are disclosing it can't tell the person that it had even been turned over to the government. Of course, national security letters didn't start with Section 215 of the Patriot Act, but it is a significant expansion in the ability of the government to gain information about people without following usual judicial processes. I remember in December of 2005, the New York Times revealed that President Bush had authorized the National Security Agency to engage in massive, illegal electronic surveillance without warrants. And I say illegal on purpose. It clearly violates the Fourth Amendment for the government to engage in electronic surveillance without warrants. And in addition, the Foreign Intelligence Surveillance Act specifically says that all electronic eavesdropping of those in the United States has to have a warrant, either under Title III of the Omnibus Crime Control Act, 1968, or pursuant to the Foreign Intelligence Surveillance Act. When the New York Times revealed this, the first thing that I did was walk to Scott Silliman's office and to talk to Scott about this and what it was likely to mean. And we had long conversations of, well, what would the courts be likely to do about it? In fact, I specifically remember talking about who would have standing to be able to challenge the government's doing this. A lawsuit was filed in the federal district court in Michigan. The judge there found that the ACLU did have standing. The United States Court of Appeals for the Sixth Circuit, in ACLU versus National Security Agency, reversed, finding that the individuals did not have standing. The Supreme Court denied review. This, of course, was a precursor to, in 2008, Congress amending the Foreign Intelligence Surveillance Act to expand the ability of the National Security Agency to intercept communications between those in the United States and those in selected foreign countries. In other words, it was statutory authority from what the Bush administration had done without statutory authority. Again, there was the question of who would have standing to challenge this. A lawsuit was brought, and the plaintiffs were very careful the lawyers were very careful in choosing who to be plaintiffs. When I teach this case in my federal courts class, I say, now these were lawyers who had clearly taken federal courts in law school and had paid attention. They got lawyers who had clients in these foreign countries who said that they were chilled from communication because of our professional duty to protect confidential communications. They got journalists who talked to sources in these foreign countries, business people who make deals with those in these foreign countries, all of whom said the communication would be chilled. The United States Court of Appeals for the Second Circuit ruled that these plaintiffs had standing, though it didn't reach the merits in terms of whether this violated the First or Fourth Amendments. But the Supreme Court, in the spring of 2013, in Clapper versus Amnesty International, reversed the Second Circuit in a 5-4 decision. Justice Alito wrote the opinion for the court, joined by Chief Justice Roberts, Justice Scalia, Kennedy, and Thomas. Justice Breyer wrote for the 4 dissenters. Justice Alito said, none of the plaintiffs is standing because none of the plaintiffs can show that their communications were intercepted or were likely to be intercepted by the federal government. The National Security Agency doesn't tell people when their communications are intercepted. Justice Breyer makes the point that this could then well mean that a law that is unconstitutional, that government conduct under it that's clearly unconstitutional, can't be challenged by anyone. Now, there still may be challenges by individuals if they're criminally prosecuted on the basis of information obtained through these wiretaps. But the ability to challenge a law, even when claimed to be blatantly unconstitutional, is denied by the court. And so what then is the effect on all of our privacy of the government having this authority and of no court being able to review it? There are 2 key cases with regard to privacy, now pending respectively in the United States Courts of Appeals for the District of Columbia Circuit and the United States Courts of Appeal for the Second Circuit. Remember, after Edward Snowden revealed that service providers like Verizon turned over metadata to the National Security Agency, a couple of lawsuits were filed. One federal judge, Judge Richard Leon in the District of Columbia, found that this violated privacy and infringed the Fourth Amendment. Another judge, Judge William Pauley in the Southern District of New York, found that this did not violate the right to privacy. These cases, respectively on appeal, will ultimately make it to the Supreme Court. And here, too, the Supreme Court will be determining what is the scope of our privacy, not just this year, but likely, in the context of the forever war, for decades to come. The third example I want to focus on is detentions. I, along with another lawyer, filed the very first lawsuit on behalf of the Guantanamo detainees. It was filed in federal court in Los Angeles on Martin Luther King Day of 2002. The case is called Coalition of Clergy versus Bush. I argued the first case on behalf of Guantanamo detainees in federal district court in Los Angeles on February 20th of 2002. I argued the first case on behalf of Guantanamo detainees in a federal court of appeals in the Ninth Circuit on July 8th, 2002. As a result of that litigation, I began representing an individual Guantanamo detainee, Salim Gurebi, in the summer of 2002. I could have never imagined when we filed that lawsuit in 2002, when I began representing Mr. Gurebi in 2002, that I would be standing here before you in 2015 with the Guantanamo detainees still there, with Gurebi still there. And Gurebi is yet to have any meaningful trial, even though he's been incarcerated for 13 years, longer than any war in American history. For a time, it appeared that the federal courts would be available to provide relief for those who were being detained, including Guantanamo. As you know, in Rasul versus Bush in 2004, the Supreme Court ruled that those in Guantanamo could bring a writ of habeas corpus into the federal courts. When Congress restricted this in the Military Commission Act 2006, and before that, the Detainee Treatment Act, the Supreme Court, on June 12th, 2008, in Boumediene versus Bush, declared these provisions of the Military Commission Act unconstitutional. The Supreme Court, in an opinion by Justice Kennedy, said that they were an impermissible suspension of the writ of habeas corpus. We are now almost 7 years later. There's not been another Guantanamo case in the interim. There's been a pattern to what's happened since. A number of district court judges in DC have granted writs of habeas corpus, only to be reversed by the United States Court of Appeals for the District of Columbia Circuit. Some judges on that circuit, like Judge Raymond Randolph and Judge Janice Rogers Brown, have been openly contemptuous of the Supreme Court's decision in Boumediene. In every one of these cases, the United States Supreme Court inexplicably has denied certiorari. My guess is that many of you have already read, and if you haven't, I highly commend to you a book that was published last month. It's called Guantanamo Diaries. It's written by Mamadou Salid. He was taken to Guantanamo in 2002. He wrote this diary in 2005. He taught himself English while in Guantanamo. It's his fourth language. In 2010, a United States District Court judge in Washington, James Robertson, found that there was absolutely no evidence to justify holding Salid. The story that he tells in his book of being wrongly incarcerated was corroborated by a federal judge. The United States Court of Appeals for the District of Columbia Circuit reversed and said that Judge Robertson applied too permissive a standard of evidence. But given that the court found there was no evidence to justify holding him, what difference does it make what standard of evidence is used? And so, still, as we are here in February 2015, Mamadou Salid remains in Guantanamo 10 years after he wrote the diary that's just been published. The detentions, of course, are not just of those who are in Guantanamo. The United States government has asserted, is in the context of the war on terror, the ability to detain American citizens, including those who are apprehended in the United States. In Hamdi versus Rumsfeld, 2004, the Supreme Court held that American citizens apprehended in a foreign country could be detained, but the court said they had to be provided due process. More troubling to me is the case of Jose Padilla. He's an American citizen who was apprehended at Chicago Airport and held for a lengthy period of time as an enemy combatant. The United States government claimed the authority to detain him indefinitely as part of the war on terror. It was only when the United States Supreme Court seemed poised to grant review in his case a second time and likely to reverse the Fourth Circuit that the United States government charged him with a crime, prosecuted him, And then the Supreme Court dismissed as moot the issue of whether he'd be held as an enemy combatant. But because the Supreme Court didn't review this, the last word from the federal courts is from the United States Court of Appeals from the Fourth Circuit. And it upheld the authority of the United States government to detain American citizens apprehended in the United States as enemy combatants without providing them a trial. Isn't that Fourth Circuit decision then exactly the kind of loaded gun that Justice Jackson was talking about in his dissent in Korematsu versus United States? Or as you think about detentions, ask yourself the following question. How many people is the United States now detaining, or has it detained as part of the war on terror? How many have been held on material witness warrants, even though there was no desire on the part of the government to really use them as material witnesses? How many have been held on immigration violations as part of the war on terror? How many have been held in rendition camps by the United States as part of the war on terror? The United States government has never told us that number. Several years ago, when he was the head of the Department of Homeland Security, I debated Michael Chertoff. It was in front of a group of federal judges. And I asked that question, and he said he couldn't answer because it was classified information. But isn't it deeply troubling, as we think of this forever war, that none of us know how many people have been detained or how long they've been detained as part of the war on terror? Fourth and final example, torture. So far as we know, this is the only time in American history when the United States government systematically designed and implemented torture. Sure, you, like I did, read the Senate report, 499 pages, that was released in December. And I would hope that all of us were sickened by it and ashamed of our country by it. To read of individuals chained in a standing position for days on end. To read of an individual kept awake for 80 hours. To read of one person being waterboarded 183 times. To read of forced rectal feeding, proceeding barbaric, inhumane, and degrading. These, of course, are just a few examples. And these were not the first reports there were of torture. Jane Mayer's magnificent book, The Dark Side, earlier documented the torture that occurred in rendition camps. Her report, like the Senate report, documented individuals who had died as a result of this torture at the hands of the United States government. There's an earlier Amnesty International report with regard to this torture. Here, too, I think the book, The Guantanamo Diaries, is so powerful. Because even though I had read all of these descriptions, to read what was done to this one man was so very disturbing. He talks about being beaten by the guards, so much so that his ribs were broken. He talks about being taken out of a boat and being threatened that he was going to drown. He talks about how women soldiers were used to sexually harass, molest, and embarrass him. He talks about how he's told his mother was going to be apprehended and tortured if he didn't talk. How could our country ever design such policies? How can our country expect foreign countries to follow international law in treating our prisoners if our country doesn't follow it when we have enemy combatants and foreign prisoners of war? Here, what I worry about in terms of Justice Jackson's prophecy is that no court has yet said that this torture was illegal and wrong. There were a couple of cases involving people who were tortured in foreign countries that made it to federal courts of appeals. There was El Masri, who was apprehended by mistake, brutally tortured for many days, and then when the government realized it was an error to have him, he was dumped on the streets of Albania. There was the Jefferson Data case, where a suit was brought against those who were taking individuals to rendition camps. In both of these cases, the United States Courts of Appeals, the Fourth Circuit and the Ninth Circuit, respectively, said that the state secrets doctrine prevented the cases from going forward. This undermines accountability in these cases, and such as a dangerous precedent for the future. There have been other cases with attempts to bring torture into the federal court. Jose Padilla brought a suit against John Yoo, arguing that the torture memos were the precipitating cause of what he suffered. And in his complaint, he details physical and psychological abuse that violates every treaty with regard to international human rights. But the United States Court of Appeals for the Ninth Circuit found in favor of Yoo on the doctrine of qualified immunity. The Ninth Circuit said it wasn't clearly established that torture was wrong, at least insofar as the right would be known to every reasonable officer and beyond dispute. But how can it be said that every government officer wouldn't know that torture was wrong and beyond dispute? Without having had courts invalidating the torture, I worry the precedent will set when there are future terrorist acts, especially when you have government officials responsible, like Dick Cheney, going on the news saying he's proud of everything that was done. I worried as I was preparing this talk that all of these examples, or at least most of them, are familiar to you. And yet, as I thought of them together, I realized that this is a place where the whole really is greater than the sum of the parts. That we haven't tended to put together all of these losses of civil liberties and think about what they mean for the future. As I've already alluded to, I wonder why we don't focus more on the loss of civil liberties. And I do fear it may be because it doesn't happen to people like us, that those who suffer these violations are Middle Eastern descent, likely Muslim, and because much more easy when it's others who suffer the abuses to tolerate them. But what's at stake is the rights of all of us. And if the rights are compromised, then all of our rights in the future are in danger. I'd conclude with the words from the late Justice Louis Brandeis from his dissent in Olmsted versus United States in 1928. He said that the greatest threat to liberty will come from people claiming to act for beneficial purposes. He said, people born to freedom know to resist the tyranny of despots. He said, the insidious threat to liberty will come from well-meaning people of zeal with little understanding of what the Constitution is about. I think what I've described says that all too often since September 11th, policies have been designed by well-meaning people of zeal, but with little understanding of what the Constitution is about. Thank you.
Dean, would you entertain a few questions from your speech? Anybody have any questions for the Dean?
Question for General Dunlap. Did you put this on YouTube?
Yeah. I think the whole conference is on YouTube.
Oh, okay. Thank you.
Ron Solomon again. Thank you very much for your speech, and it's very enlightening. And I could never recall that data, so your ability to do so affords me the ability to listen to somebody so fluent. My question is, you mentioned a lot of Supreme Court precedent and various court precedent, and I'm wondering if the courts are the proper vehicle at the end of the day for resolving some of the loss of civil liberties that you've identified, and instead perhaps it's the more political institutions of government should be the lead, should take the lead, and that would only happen until we have a political settlement on these issues. Is that a correct observation?
It's a great question, though I disagree. I think when it comes to protecting rights in a crisis, we most of all need the courts then. Then I think the framers of the Constitution knew that there'd be a temptation in times of crisis to want to centralize power and engage in repression. It's been said by others that the Constitution is really an elaborate edifice to make sure that our short-term passions don't cause us to lose sight of our long-term values. There will be a temptation after an event like September 11th or in the context of a war to want to protect the country at all costs, even when it means the loss of rights. It's the judiciary with life tenure that we should be able to turn to enforce the Constitution. I think the courts have failed to do this over the course of American history. There are exceptions I could point to, but overall, I think the court has not lived up to what it's there for. But I don't think you can trust the political process. I think the events in September 11th say that the political process will do what pleases the people and what's expedient to protect national security. The protection of rights has to be in the hands of the unelected judiciary.
Dean, let me pose a question. Do you see any case where the state secret doctrine would be appropriately applied? You know, what in your view of the world, where are the points at which government's interest in national security, which is, if we believe Hague v. AG, is the most important governmental interest? When should they interpose themselves, if at all?
Obviously, national security is important. I'm not in any way questioning that. I am saying we should be sure before we take away rights that it's really doing something to make us safer. The reason I began with the history that I did was history shows us that when we've lost rights in the past, it hasn't done anything to make us safer. I also obviously believe that there are instances where secrecy is needed. But secrecy should lead to a dismissal of a case, especially when there's a claim of major invasion of rights, only as a last resort. There are many ways to protect secrecy before you get to the dismissal of the case. There is, for example, the Classified Information Protection Act, CIPA, which gives the federal courts the ability to handle matters. There's certainly the ability to have in-camera proceedings. We know that there have been many cases literally filed under seal. And so there's the ability to deal with that. To give an example of the abuse, to try to address this, I was the lawyer who filed the civil suit on behalf of Valerie Plame and Joe Wilson against Dick Cheney and Karl Rove and Louis Libby and Richard Armitage. It claimed that it was a violation of Valerie Plame and Joe Wilson's rights. And I argued it in the federal district court in DC, and I argued it in the DC circuit. One of the two grounds that the DC circuit gave for dismissing their suit was secrecy, saying it's possible that their lawsuit, when it went forward, could reveal secrets. Now, given all that was in the press, given the prosecution of Louis Libby in federal district court, I doubt that much in the way of new information was going to come out. And even if there was still some secret information, why not wait until it comes up to decide what to do? It may very well be those parts of the case could be handled in camera. CIPA could be used, or something like CIPA could be used. But instead, anticipating the possibility that the information might come out was the sufficient basis for the dismissal of the lawsuit. Now, my way of characterizing this afterwards was this really was the classic somebody kills his or her parents and then pleads for mercy for being an orphan, because it was these defendants that revealed classified information, and then the court says, well, it might lead to the revealing secret information, so we have to dismiss the whole lawsuit. With regard to the El-Masri and the Jepson data case, the court at the earliest stage dismisses these claims against rendition and torture based on secrecy. The last thing we should do when there's no other way to protect secrecy is dismiss the case, because here the result was that claims of brutal, inhumane torture were not subject to judicial accountability because of the possibility that secret information might come out. So I'm not denying that there may be the instance, but make that the last resort.
Steve?
Yeah, sorry. Thanks, Erwin. So I guess you brought up Wilson versus Libby, which strikes me as an interesting point of departure, because the other ground the D.C. Circuit relied upon in that case, as you well know, was the refusal to recognize a cause of action under Bivens. I suspect that not everyone in the room is intimately familiar with Bivens and its consequences, but I wonder how much of the concerns you raised in your talk could be substantially ameliorated if Congress were to consider creating a federal statute along the lines of what it's already done for violations of federal law by state officers in Section 1983.
We should be so fortunate that Congress would adopt such a statute. What Steve's referring to, if this isn't the area of law you practice, is that whenever a state or local government official or a local government violates the Constitution, a suit can be brought for money or injunction under 42 United States Code, Section 1983. There is no similar statute that authorizes suits against federal officers who violate the Constitution. It comes from the case that Steve mentioned, a 1971 Supreme Court decision, Bivens versus 6 unknown named agents of the Federal Bureau of Narcotics, where the Supreme Court said you can bring suits against federal officers themselves for constitutional violations. But since 1980, without exception, the Supreme Court has continually cut back on the availability of Bivens suits. And one of the grounds that the D.C. Circuit gave for why they dismissed the suit by Valerie Plame and Joe Wilson was that there wasn't a Bivens suit available because there was a statute that existed, the Privacy Act. And that's what the court said. Now, there's many problems with this. Why should the existence of a statute preclude a constitutional claim? As to one of these plaintiffs, Joe Wilson, he wasn't a government employee. The Privacy Act didn't apply to him at all. Why should his suit be barred? Even more, the Privacy Act doesn't apply to the president and the vice president. So for 3 of these defendants, the statute was completely inapplicable. That's for Cheney, Rove, and Libby. So why should an inapplicable statute bar a suit at all? And yet the D.C. Circuit said no Bivens suit was available, and the second ground was the concern over secrecy. I do think it would be far superior for Congress to pass a statute like 1983 against federal officers. I don't think it would help, though, if the court's going to then dismiss based on the state secrets doctrine anyway.
Yes, sir. In the back there.
Question is from Rick Deveau. Given your very lucid description of sort of 200 years of history of periods when America's in conflict, and the courts, all the way up to the Supreme Court, kind of ruling against the rights of U.S. citizens in sort of contrary to the Constitution. I mean, boiling all that down, you know, your basic cause was sort of this misappropriated view that it will make us safer when it hasn't, and also that the victims of this process are people that don't look like us. I just wonder if there might be other factors at work here, say structural or process issues that cut to the heart of the U.S. legal system, or perhaps factors unique to America, to the way we think, to the way we operate. I wonder if you could explore perhaps some other causes besides the sort of don't look like us phenomenon.
And I don't mean to reduce it to that. I do believe, though, that there would be much more of an outcry about what's been done if it was our children who are suffering this. I think it is much easier to look the other way. That's the only point that I wanted to make. I'm not saying that's the primary cause of what's been done, but I think it's something that's been ignored. I mean, another thing, I think that we've had a Democrat in the White House since 2008 has meant there's been a lot less criticism of this policy. That when there's a Republican in the White House and Guantanamo was going on, people were much more willing to criticize Guantanamo. I think people have given President, especially progressive, given President Obama, too much of a pass in terms of his promise to close Guantanamo. I understand the statutes that limit it. The Obama administration, in terms of its prosecution of journalists and enforcing secrecy, the Obama administration, in terms of the use of the state secrets doctrine, I don't think we've criticized the Obama administration enough. I think that's part of the cause, too. While in one sense, what you describe is my painting a bleak picture, as Scott said, I'm a lifelong Chicago Cubs fan. I believe this is the year the Cubs are going to win the World Series. I believe that things can be better. I believe the courts can do a better job. I believe our presidents can do a better job. But I think it will only happen if we talk about it and if we hold them accountable for what they do.
Yes, ma'am.
Rochelle Howard. My question is regarding transparency. When I left Afghanistan for the last time in 2011, I was advising the Afghan police on anti-corruption, and the group of us operated on the premise of transparency. We were also able to use transparency with protecting classified information. So my question would be, in this realm of trying to not violate our civil liberties when the government always asserts the State Secrets Act, could there be a valid argument for transparency that comes to some middle ground?
Yes.
And why?
I-
How?
uh, yeah, I am not saying that civil liberties always should prevail. That would be a nonsensical position. I'm not even saying that free speech is absolute. I believe there are times that free speech has to be restricted. I believe that certainly electronic surveillance is necessary, though I believe it should be done in compliance with the Constitution and the laws. I believe that people should be detained, but we should follow procedures. I don't believe torture is ever justified. So I think that what you talk about in terms of transparency is important. It's why I thought the Senate report that came out in December was so important, because it did make transparent what had been done by our government. We should know about that. Are there middle grounds? Always there are middle grounds. And that's why I said in response to Charlie's question, I think that there may be instances where some cases have to be dismissed based on the state secrets doctrine, but only as a last resort, and only if we really know in that case there's truly no other way to protect crucial national security information.
Jane?
Yeah, thank you for that extraordinary overview, and particularly for highlighting the impact on Muslim Americans, which often is not talked about in those ways. My question, and you began to get to it, is what do you regard as the biggest human rights challenge with the Obama administration? I mean, many of the examples you went over are ones that we're feeling the aftermath from the early days post 9/11. So currently, what are the biggest challenges?
I think some of those challenges continue. I mean, there's still 125 people in Guantanamo. Now, again, I don't want to solely blame the Obama administration for that. After all, Congress has passed statutes that make it so difficult to remove people at Guantanamo. But I don't think we should forget there's still 125 human beings who are in Guantanamo, almost none of whom have ever been tried. And that's why I think the Guantanamo Diary book is so powerful. The Obama administration is defending the turning over the metadata to the National Security Agency. It's arguing in the DC Circuit, the Second Circuit of that. The Obama administration, thankfully, repudiated torture from the very beginning. But I strongly criticize the Obama administration for not bringing criminal prosecutions against those who were responsible for the torture. What was done was a violation of United States law, the Torture Act, and I think the only way to express that this is wrong, the only way to prevent this being Justice Jackson's loaded gun for the future, is to set the precedent that this is unacceptable. And I think criminal prosecution would do that. I think the failure to criminally prosecute the torture, the failure of the courts to condemn it, really runs the risk that the next time it'll happen all over again.
Yes, sir. Jarrett?
Jeremiah Mahoney. I'm wondering if you accept the proposition that combatants can be detained until hostilities have concluded.
Say the question again, I didn't hear it.
Do you accept the proposition that combatants can be detained until hostilities have concluded?
I accept the proposition that under the Geneva Accords, prisoners of war can be detained until the hostilities are concluded. I think the difficulty with that is, what if we're in the context of a forever war? I also believe that if we should be following the Geneva Accords with regard to those who are holding. I don't accept what started with the Bush administration, that there's a category of detainees where no law applies to them, where they're not prisoners of war and they're not covered by the Constitution. Either the Geneva Accords should apply and or the Constitution should apply. There shouldn't be a lawless zone of individuals who can be held indefinitely with no law applying to them. And that's what concerns me so much. So yes, if there's appropriate procedures, you can detain people. I'm not saying that everyone in Guantanamo should be released, but I am saying that the way we know whether somebody is a danger or a threat or has done something wrong is a trial. We provide due process, we hear evidence, and that we haven't done.
Well, wait a minute. I object on your premise, because not every combatant has committed a crime. Certainly, German POWs in World War II had not committed a crime under the law of war, but yet we had not released them until the hostilities concluded.
But I think the challenge, and that's what this conference is about, is What do you do in the context of a forever war? What do you do in the context of now people have been there 13 years, which is longer than any war in history. And in light of what's going on around the world, there's no likelihood it's going to end. Does that mean we can keep them for the rest of their lives? That's the question that I'm raising. To me, that's deeply disturbing.
Well, first of all, this is not the longest war in history.
No, of course not. It is the longest in American history.
Jerry, could you grab the microphone?
It's okay.
Okay, my point is that it's not the longest war in history.
Of course not.
And just because the war goes on, presumably forever, maybe not, combatants should not have to be released to the battlefield or to whatever other activities they're going to undertake to resume their status as combatants by the other side.
I'm not disagreeing. I just want to make two small points. One is I think we as a country have to think about what it means then to detain people in the context of forever war. If we expect that this is a war that's going to go on, as President Bush said, long beyond our lifetimes, are we comfortable holding people for their entire lives? And second, what procedures should we use? You're right, it doesn't have to be they've committed a crime, but there has to be a sufficient basis for detaining them. How do we know that they're not there by mistake? We now know that many people were brought to Guantanamo by mistake. If you read Mamadou Salid's book, if you read Judge Robertson's opinion of the district court in the District of Columbia, there's reason to believe that he's there by mistake. He hasn't had any kind of a trial. So if we're going to be detaining people, we've got to have more procedures than what we've provided. That's my point.
Bobby? Yeah, she's hustling over here. Hard to believe she was a sprinter in college, but.
Still got it. Erwin, I have two things I'd like to get your reactions to.
Let's do one at a time.
Yes. So first, following up on the discussion just had, can you I take it you're not satisfied by the fact that the detainees do now have habeas review in federal court plus annual administrative review to ostensibly deal with the forever war aspect you're talking about. So I'd like to hear about what is it in that process that's not up to the standard you'd like to see? What particular things could be changed?
First, habeas review since Boumediene, because of the D.C. Circuit, has proven empty. There are so many cases, like Mamadou Salid, where the district court granted relief and the D.C. Circuit reversed, and the Supreme Court has denied review. The D.C. Circuit has adopted standards of evidence and standards of deference to the military. They're going to make it very difficult to have meaningful habeas corpus. Maybe now, as the composition of the D.C. Circuit has changed, the D.C. Circuit will allow habeas corpus. But you know all those cases as well as I do. And it's inexplicable to me that the Supreme Court, for 7 years, has not taken another Guantanamo case. With regard to the administrative procedures, until recently, the procedures of the Combatant Status Review Tribunal procedures. And those were the most minimal of due process, if due process at all. I cannot relate what happened in my client's CSRT because it's classified information, but to call it a semblance of due process would be too much. Now, there are now better annual reviews, and it'll be interesting to see how those work. And of course, there's been a reduction in the number of people in Guantanamo. And yet I find it so powerful. If you read Guantanamo Diaries yet, Mamadou Salid, as he describes what happened to him, every bit of it is corroborated by Judge Robertson's opinion in the D.C. District Court. And yet, he remains in Guantanamo in 2015. If he's there with what federal district court judge said, no basis, how many others are there on no basis? And then what does that tell us about the failures of the administrative procedures?
I think we have time for one more question. The Army officer in the middle back there. Yeah, that limits it down.
Second Lieutenant Brown, U.S. Army Reserve. Oh, wrong one.
No.
It's okay. We're lost too. Okay, so in regards to possibly moving forward with due process for the detainees, and with I guess the non-working of the judiciary here, would it
Let's not make it too hard a question since we only have 60 seconds left.
would it be better to proceed with due process in the United States, or maybe extradite that to Geneva or back to Afghanistan where they were originally taken as POWs? What's your opinion on that?
I think it should be in a military commission or in a civilian court. I have great faith in the military and the military commissions, especially with judges like Judge Silliman in reviewing them and on the appeals court. I also have tremendous faith in the Article III judiciary, and I think the Article III judiciary can handle all of these matters. But these individuals should be tried in a military commission or in an Article III court. But we've been imprisoning them. It's the authority of the United States. It should be in an American proceeding, be it military or civilian. Thank you so much, and thank you for having me here.
Thank you so much, Dean.